Hi, I'm Michael Lestrito, managing attorney here at Chisholm Chisholm Kilpatrick.
And I'm Emma Peterson, a partner here at the firm.
Welcome back. Today we're tackling a phrase that a lot of veterans feel deep in their bones. Hurry up, VA. If you've ever waited months or even years for VA to act on your claim, this episode is for you.
We're going to talk about something called a writ of mandamus, which is basically a legal way of saying, come on, VA, do your job. We'll break it down what it is, when you can file one, and why they matter in veterans law.
So let's start with the definition. A writ of mandamus is a court order that tells a government agency or official to perform a duty they're legally required to do.
In our world, that usually means asking the U.S. Court of Appeals for Veterans Claims, the CAVC, to force VA to act when it's dragging its feet.
It doesn't ask the court to rule on the merits of your claim, just to tell VA to move forward when it appears to have stalled.
So, when can a veteran actually file one? Writs are not for normal delays, they're for extraordinary delays, situations where VA has just stopped moving for no reason.
Think examples like VA sitting on a remand for years, BVA not issuing a decision after a hearing, regional officer failing to act on a granted appeal. You have to show that VA has a clear legal duty, that they have delayed unreasonably, and that you have no other options.
The process starts with a petition to the CAVC. That's a legal filing that lays out the facts, the delay, and why the court should step in.
After that, the court usually gives VA a chance to respond. If VA has been sitting on a decision or a step, sometimes that's enough to get VA to finally take action. In some cases, the court schedules a hearing or issues an order for VA to explain the delay.
Most writs don't end up with a dramatic courtroom showdown or even a victory necessarily, but it often isn't necessary to actually win the writ. If VA has dropped the ball, then simply filing the writ of mandamus often gets VA to act, which is all you really want.
Which is good, because writs are hard to win if VA is still technically doing something. Even slow movement can make it hard to prove unreasonable delay. But if you are working with an experienced VA-accredited advocate, someone who knows the system, then they can recognize a situation where a writ might be appropriate.
Thanks for joining us, and if this helped you, share it with another veteran. Take care.